Hello, Miss
Yes.
Patty.
Yes.
Oh. Okay, do you want me to send you copies of these pleas that Jeff has just finished? So you'll have a copy? Or does it matter?
No, just as long as they're completely filled out.
Okay.
Every heading, every style, every case number, every box in the plea admonishments, as long as everything's filled out, just read me the terms.
Okay. Okay. Hang on, I think we've got one. I just need to get Jeff and we'll be ready.
Okay.
Judge Martin?
Yes, ma'am.
Okay, we're ready with Jeff Sanders and Mr. Vela.
Okay, I'll be there in just a second. Right, Mr. Vela, this is CR 20143, CR 2273. Are you Jose Luis Vela?
Yes, Your Honor.
All right, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can put your hand down. If you have gum in your mouth, I need you to spit that out. Find a trash can. All right, Mr. Sanders, is this going to be a plea before the court today?
Yes, Your Honor, it is.
Can you tell me the terms?
Judge, he'll be pleading guilty to the lesser charge of aggravated assault in CR 20143, and then the other case, the UMB, I'm not sure what the cause number is offhand. That'll be 1245 into the aggravated assault case.
Is that an aggravated assault deadly weapon or SBI or
Deadly weapon. Yes.
deadly weapon?
Yes.
And what's the plea?
3 years TDC.
And the back time?
9 days.
90, 90?
9.
9?
We take 90, but it's 9, Judge.
Okay. Court costs?
$290.
Any reimbursement fees?
$35.
Is there a fine?
$2,500.
Any type of weapon forfeitures or destructions?
I don't think we've got a form for that, but
Well, it would be on the second page of the judgment or the third page of the judgment, right above my signature line, if there was a weapon forfeiture or destruction.
yeah, there's a finding that there was a deadly weapon used, a firearm. It doesn't specifically say for that to be forfeited. Obviously, we would forfeit that, but I don't think there's any language in, at least in that section of the judgment, indicating that.
State, are you aware, is there a weapon seized in this? Are y'all taking forfeited or destroy it?
Judge, there was a weapon. I do believe it was seized. Let me look into that very briefly. Judge, there is a Canic 9mm model TP9SF handgun, but I do not believe it belonged to, well, used by this defendant, it did not belong to this defendant, so we would not have a seizure from this defendant.
Okay. All right, Mr. Vela, are you a United States citizen?
Yes, Your Honor.
Do you read, write, and speak English?
Yes, Your Honor.
Have you ever been diagnosed with any type of mental condition?
No, Your Honor.
In this case, in both of your cases, you're represented by your attorney, Mr. Jeff Sanders. Are you pleased with his representation of you?
Yes, Your Honor.
You feel like you've had enough time to discuss your case with him and have all of your legal questions answered?
Yes, Your Honor.
Is there anything about the plea agreement that you have signed and read today that you do not understand?
No, sir.
Mr. Sanders, do you believe your client to be competent today?
Yes, Your Honor, I believe he is.
And you've explained to him his legal and constitutional rights?
Yes, Your Honor, I have.
All right, you heard Mr. Sanders tell me what the terms of the plea agreement are. Is that your understanding?
Yes, Your Honor.
All right, Mr. Vela, you are charged by indictment with a first-degree felony offense of aggravated robbery. However, the plea agreement poses that you plead guilty to a second-degree felony offense of aggravated assault with a deadly weapon that carries a range of punishment of not less than 2 years or more than 20 years confinement in TDC and a fine not to exceed $10,000. Do you understand that full range of punishment?
Yes, Your Honor.
I find that the proposed plea agreement fits within the range of punishment as allowed by law. So, Mr. Vela, at this time, I'm going to ask you, how do you plead to aggravated assault with a deadly weapon, second-degree felony?
Guilty.
And Mr. Vela, are you pleading guilty to that charge because you are guilty of committing that charge?
Yes, Your Honor.
Has anyone threatened you or forced you or pressured you to plead guilty to this charge?
No, sir, Your Honor.
All right, the court will accept the defendant's plea of guilt. Mr. Sanders, is there any objection to States 1?
No objection.
All right, States 1 is admitted into evidence and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state, and do we have victim compliance?
Judge, state is in compliance with victim impact. We have not received a response to the victim impact statement, but we are in compliance. We have sent it, I believe, multiple times.
Anything further from the defense?
No, Your Honor.
All right, Mr. Woodwhite, can you give me a brief summary of the facts supporting the plea?
Yes, Your Honor, I'd be happy to. Judge, on or about the day in question, February 3rd, 2020, 3 individuals go into the complaining witness's home, one of whom is holding her son at gunpoint. That is Mr. Vela, is the person with the firearm. She throws a beer bottle at the defendant. He turns and fires a single shot in her direction. The co-defendants assault the victim. They take $3,000 cash and a gun from the complaining witness. A few days later, in school, there's some rumor mill going on. We have confessions from 3 of the 4 defendants, including Mr. Vela.
Who's the victim in this case?
Cameron Chernut.
Mr. Sanders, any objection to that narrative?
No objection.
All right. Based on the evidence before the court will find that there is sufficient evidence to convict Mr. Vela of this charge. Court hereby finds him guilty of the lesser included offense of aggravated assault with a deadly weapon. Court finds that a deadly weapon, namely a firearm, was used in the commission of this offense. Court assesses punishment at 3 years confinement in the Texas Department of Criminal Justice. Court awards Mr. Vela 9 days credit towards that sentence for time served in this cause. Court orders court costs of $290, a $2,500 fine, and $35 reimbursement. Court also dismisses CR 2273, the unauthorized use of a vehicle, under section 1245 of the Texas Penal Code with the defendant's plea in this cause. Mr. Vela, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of your sentence. I'm going to have you go with the bailiff to be fingerprinted, and then you'll be taken into custody at this time.
Yes.
Yes, ma'am, Mr. Abraham.
Hey, we also have Brittany Arnold, and he's gonna do her.
Mr. Sanders, go ahead and tell me what the terms are before Ms. Arnold gets up there.
Oh, Judge, it's not for a plea.
It's an arraignment,
Oh,
Judge.
it's an arraignment. And do you have the indictments there with you, Mr. Sanders?
I think I do, Judge.
Have you gone over those with her?
We had already talked, yes, once she was out of the COVID quarantine at Henderson County Jail. Now, got it.
All right, court calls CR 21-5 and 6, State versus Brittany Cheyenne Arnold were set for arraignment today in each charge. Mr. Sanders, has Ms. Arnold been presented with the indictment in each cause?
Yes, Your Honor, she has. Her name is spelled correctly in each indictment. We've had a chance to read through the indictment and also talk about the potential punishment range with each case. We would waive the reading of the indictment, waive the formalities of arraignment, and enter a not guilty plea as to each of these two charges.
All right, the court will enter Ms. Arnold's plea of not guilty into the record. Court will set Ms. Arnold for pretrial. Mr. Sanders, remind me, what, either a Tuesday or a Thursday is not good for you. Is it typically Thursdays that are difficult for you?
Now, usually Thursdays are better.
Usually Thursdays are better. Well, morning I went the other way when you weren't there, so we may have to move the one I set for Tuesday because I was thinking Thursdays were difficult for you. Usually Thursdays, so. Sorry, I don't have another Thursday available until May 27th, and that's too far out. I have earlier Thursdays, but I don't think would give you enough time. I've got about 3 weeks from today, but
And Tuesdays are fine too, Judge. That should be, we can make it work.
how about Tuesday, May 11th?
I'm sorry, what day, May?
May 11th.
Okay, yeah, that'd be fine.
Is that fine? All right, court sets this for pretrial hearing on that date. And Ms. Arnold, if you make bail in this case before your next court hearing, then your court hearing will revert to 9 a.m. at the courthouse. If you don't make bail and you remain in jail, then we'll appear like we are today, okay?
stay on this.
This is Mr. Carmona.
Yes, sir.
Yes, sir.
All right, this is cause number CR 24-3, State versus John Michael Carmona. Are we entering a plea today?
Yes, Your Honor.
Can either one of you tell me the terms?
Judge, it's, the state's abandoning the 2 enhancement paragraphs. So it'll be a plea to 30 days in jail under 1244A, and then a $3,500 fine, and then $180 in restitution. And he has 2 days credit.
2 days credit towards the 30 days?
Yes.
So it was originally indicted state jail felony and then enhanced to a third, the 2 priors that are being abandoned?
That's correct. Your
Yes.
Honor.
All right, Mr. Carmona, if you will, raise your right. I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. Mr. Carmona, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
Yes, sir.
What have you been diagnosed with?
Bipolar.
Are you currently undergoing treatment or on any medication for bipolar?
Yes, sir.
Do you feel like that treatment or your medication has given you the ability to understand the proceedings today against you?
Yes, sir.
Okay, thank you. In this case, you're represented by your attorney, Mr. Jeff Sanders. Are you pleased with his representation of you?
Very much so.
Good. And you feel like you've had enough time to discuss your case with him and have all of your questions answered?
Yes, sir.
Is there anything about the plea today that you don't understand?
No, sir.
Okay. Mr. Sanders, do you believe Mr. Carmona to be competent today?
Yes, Your Honor, I believe he is.
And you haven't seen any concern regarding his bipolar diagnosis that gives you concern?
No, Your Honor.
Okay. Let's see, Mr. Carmona, you are charged by indictment with the state jail felony offense of possession of a controlled substance, penalty group 1, less than 1 gram. If prosecuted under section 1244A of the Texas Penal Code, that would mean that the range of punishment for this charge would be a maximum, it'd be from 0 days to a maximum 365 days in the county jail and a fine not to exceed $4,000. Do you understand that range of punishment?
Yes, sir.
Understanding that, Mr. Carmona, how do you plead to that charge?
Guilty.
And Mr. Carmona, are you pleading guilty because you are guilty of committing that charge?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty?
No, sir.
All right, the court accepts the defendant's plea of guilt. Mr. Sanders, any objection to States 1, the stipulation of evidence?
No objection.
States 1 is admitted into evidence and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state,
No, Your Honor.
from the defense?
Judge, just a couple of things. With the fine, the $3,500 fine, he has the $3,500 money orders today that he can pay. As far as he was asking if he could delay when he starts his sentence to the evening of April the 6th. I believe he's scheduled to have a COVID shot next week. And I know that the state's been very patient with agreeing to reset a couple other times because of other health issues involving his eyes, eye surgery.
And I appreciate it.
So he was, and I believe there's maybe another appointment on April 6th. We were asking if the court would allow him to wait until, to turn himself in the evening of April 6th.
State?
Judge, I told Mr. Sanders the state obviously would have no objection to him requesting that. However, the state is unable to agree to that at this time. We've made significant concessions for Mr. Carmona in light of his medical history. And at this point, Your Honor, I feel like there's always going to be another doctor's appointment, something else coming down the pike. Eventually, you know, it's just time, in my opinion, for Mr. Carmona to sit out his days. Like I said, significantly fewer days than we originally discussed because of those medical issues. It's going to be the state's position that Mr. Carmona needs to just go on and start serving his time today.
Mr. Sanders, do you want to make any type of argument?
Judge, just if Mr. Carmona has any other details about the two different appointments he's got
Well,
coming up.
My wife just recently today received one follow-up appointment on the 6th, and that would be it. There would be no problem on April 6th, the evening of April 6th, it's in Tyler. As soon as I get done with that appointment in Tyler, we could just stop here and I would have no problem starting my sentence, because I did the crime and I'm ready to make my just due. And I just beg the court to make one more acceptance, because I appreciate everything that the court has done up to this point, and I want to make good on my end. I just don't want to lose my eye, and I assure you there would be nothing coming up after that would interfere in my 28 or 30 days of incarceration for something that I know y'all made very many accepting, you know, more than y'all would do. And I appreciate it. But I just asked for this one last appointment, and April 6th on my way back from Tyler, I promise you that I would be here ready to give you my time.
And on April 6th, your follow-up appointment is regarding your eye, or is it regarding COVID shot?
My COVID shot is next Wednesday. And then I have the eye appointment on April 6th.
All right, give me just one moment. I'll go through your case here.
After that, it would be like 2 months or 3 months before I have to go back.
All right, Mr. Carmona, what I'm going to do is I'm going to grant your request. I'm going to let you appear I'm going to order you to appear at the Van Zandt County Jail on April 6th at 8 p.m. to begin your sentence.
Yes, sir.
All right. I looked through your case. I show that you haven't missed court. I understand you've got medical issues. If I were in your shoes, I would be worried about my eye. And the COVID shot is important. So I've had other men and women before me that have asked for the same thing, and I've denied it and I've granted it. And sometimes when I grant it, they don't show back up, and it leaves me with a taste in my mouth. And then other times I have granted it and people have done what they're supposed to do. So I'm looking at you. I'm looking at you subjectively, case by case, and I'm gonna err on the side of you giving me your word as a man that you're gonna uphold your responsibilities. I can promise you this, though: if you don't show up, that's going to constitute escape, and it's going to be a new charge. It's going to be a new charge, and I don't think the state's going to be as willing to give you any type of reduced sentence or abandon any type of paragraphs or anything of that nature next time. So there's still a lot of consequences if you do not appear.
Yes, sir. I understand that completely. I appreciate it very much, sir.
So you've got your money with you today. So when you leave the jail, I want you to take it and bring it over to the courthouse and take it down to the clerk's office on the 3rd floor. And I want you to go ahead and pay that today. And state, if you can have Miss Abney email Miss Barker a commitment.
Yes, sir.
then with that date of April 6th, then we won't, I don't know what the judgment says today. Does the judgment today say April? Does it
Yes,
say today's date?
The
It says-
judge reflects today he's going into custody. So that was my question for you, was whether an order of commitment would rectify that or whether we needed to actually amend the judgment.
Well, since he's not going to TDC, I'll tell you what, I'll just interlineate the commence date to begin on the 6th on the judgment. And then we can send Mr. Sanders or send Mr. Carmona, if he's got an email, we can send him that. Mr. Carmona, when you show up on the 6th, you're going to have your ID with you and you're going to have the judgment with you. Otherwise, they're not going to let you in.
Okay.
Okay.
Yes, sir.
All right. So with all that being said, the court finds that there is sufficient evidence to convict Mr. Carmona of this offense. Court will allow the state to proceed under section 1244A of the Texas Penal Code. The court convicts Mr. Carmona of possession of a controlled substance in penalty group 1 less than 1 gram. Court will assess sentence at 30 days confinement in the Van Zandt County Jail, with that sentence to commence at no later than 8 p.m. on April 6th of 2021. Court assesses a fine of $3,500, $180 restitution. The court awards Mr. Carmona 2 days credit towards the time or towards the sentence for the time that he has spent in jail on this cause. So, Mr. Carmona, I'm going to have you step over with the bailiff to be fingerprinted on that judgment. And then once it gets back to me, I'll sign it and we can get if you come over to the courthouse, we can get a copy printed out for you. You'll go down and see my coordinator, Ms. Barker, at the other. You'll pay the money on one end of the hallway with the clerk. And then on the other end, you'll see my coordinator, Ms. Barker, and she'll give you a copy of that judgment.
Yes, sir.
But let me correct that. If Ms. Abraham's out there, can we just make a copy of the judgment today? Just for his record, and then we can send a signed one over later.
Yes, sir.
Okay, but you'll remember you'll need to have your ID when you show up, or they're not going to let you in.
Yes, sir.
All right, go ahead and get fingerprinted, and then this way and make payment on your fine.
Okay, thank you, sir.
You're welcome. Hello,
Good afternoon, Your Honor.
how are you?
I'm good. How are you doing, sir?
Which hat are you wearing today?
Well, this hat's just on, it's just on the side for a moment, and I'm back into my other hat. This
Understand.
Thompson is ready though with Mr. Burgess, if you're ready to hear them.
Yes, thank you. Yes. All right, this is cause number CR 21-8, State versus Troy Wayne Burgess. And we are set for arraignment today. Ms. Thompson, have you gone over the indictment with your client?
Your Honor, Mr. Burgess suffered a major stroke in November. He was released, I believe, to his family in February with complications. I had discussed this yesterday somewhat with the district attorney about the possibility of sending it out for 60 days. See if he could recover some of his mental faculties and clarity. Or if the court would prefer, I could go ahead and file a motion for evaluation, mental evaluation, but I do not believe that we're ready to go forward.
State, do you have any position?
Judge, I have been contacted by Mr. Burgess, or our office has been contacted by Mr. Burgess's parents, who are the victims in this case. And they corroborate what Ms. Thompson's saying about his medical history, although we have not received any official documentation on that. So we would not be opposed to a 60-day reset this one time to get that documentation to see what Mr. Burgess's capabilities are going to be going forward on this case.
All right, the court will reset Mr. Burgess then until May 25th for arraignment. And we'll regroup then and see if Mr. Burgess has made any progress on his cognitive abilities.
Thank you, Your Honor.
Miss Burns, are you there with Mr. Burgess to discuss the pretrial release?
Yes, sir.
So you may, you're not going to be able to discuss that with him. If you've already had him sign it, just make note that we may have issues with his competency in understanding what the pretrial release conditions are.
Yes, sir.
Oh, actually, I think, okay, yeah.
Okay, Judge, we have Mary Dean ready.
Thank you, ma'am. Call CR 2288, State versus Mary Louise Dean.
No, yes, sir.
All right, Ms. Dean, set for docket call today, Ms. Thompson.
Your Honor, Ms. Dean, I've spoke with her. She has advised she didn't care. So I guess we're going on the trial account.
I'm sorry, you're going to have to repeat that. I didn't hear any of that.
I'm sorry, the math makes it difficulty. She has stated that she doesn't care one way or the other. So I guess that means we're going on the trial account.
She doesn't care about what, one way or the other.
About whether she wants to take a plea or take go to trial. And I've explained to her what the offer was. And she's unwilling to accept that, so the only option left is trial. Your Honor.
Okay, and what's the offer?
10 months state jail.
10 months, 10?
Yes, sir.
Okay. Ms. Dean, do you understand that if the court places you on the jury selection docket, that your case will not be number one for trial for quite a few months? Do you understand that?
Yes.
You guess?
I don't really know what that means.
Okay, that means if I put you on my jury selection docket, that means I put you in the group of cases to go to trial. Your case will not be selected for trial for several months because there's other people waiting for jury trials, and the courts are just now starting to retry cases. So do you understand that if you don't make bail in this case, you could be sitting in the jail for several months? Do you understand that? Do you understand?
I do now.
Okay. So the offer from the state is 10-month state jail, and you can accept that. You can counter offer it. You can reject it. Right now, Ms. Thompson's telling me you've considered all of your options and you're rejecting their offer of 10 months. Is that correct?
Well, Your Honor, that was the last plea agreement that I guess they have given me.
I understand, but you're telling me, and you told Ms. Thompson that you want to reject that and you just want the court to set you for a trial, and you want me to bring in a jury and let the jury determine if you're guilty. And then if the jury determines that you are guilty, then you would have to make a decision whether the jury or the court decides your punishment. If the jury finds you not guilty, then you're acquitted and you're done. But if they find you guilty of this offense, then the jury or the court would make the decision on what your sentence is. Do you understand that?
I guess so.
You do? Okay. So you're rejecting their offer of 10 months and you're asking the court to give you a trial. Is that right?
No, I guess I'd like to take the 10 months then, if I could, sir.
Well, let's do this. Let me let you talk a little more with Ms. Thompson, and I want you to be sure when you come back up, I want you to understand all of your options, because this court is not trying to convince you to take 10 months. I'm just trying to make sure that you understand what the plea offer is and how we're going to go about trying your case and when it will be that we'll likely try your case. I just want you to have all the facts so that you can make an informed decision based on whatever it is that you want to do in the case. And you get to make that decision. Ms. Thompson doesn't make it for you. I don't make it for you. And the prosecutors don't make that decision. You get to make the decision on how you want to proceed with this case. Okay. So I'm going to recall your case in just a few more minutes, and I want you to listen to Ms. Thompson, and then Ms. Thompson is going to explain to you the evidence. She's going to explain to you about trial. She's going to explain to you about the plea agreement. And then when you come back up, I don't want any hesitancy. I want to be sure that you understand what we're doing here today, and that when you make a decision, it's a decision that is based on all the information that you have. Okay? All right. So I'll call you back up in just a moment. Do we have Ms. Carter?
No, the jail transferred her over to Henderson County this morning.
Okay.
I've sent them an email asking them if we can Zoom, but they've not gotten back with me.
All right, we'll check on her again. Let's let Ms. Thompson go speak with Ms. Dean, and once we conclude with Ms. Dean, if we haven't heard back from Henderson County, then we'll just reset her for another time when Ms. Thompson may be here.
Okay, and is Mr. Knoll on?
Yes, Mr. Knoll and Mr. Ugler are available. I just haven't brought them in because they're
Okay.
clients.
We'll go
But
get their clients, and then Mr. Fitzgerald, the first man, the Laquaylen Fitzgerald.
Yes.
He told me that he's hiring an attorney, so I'll just.
Okay.
look him up and you can.
Yes, so yeah, go ahead and bring Mr. Ugler's client and Mr. Knoll. They're available. I just haven't brought them in because their clients haven't been up there yet.
Okay.
All right,
We'll be
thanks.
back with you in a minute.
Thank you, ma'am.
And y'all quit laughing at me in my, looking up at the screen.
Okay, I'm making noises.
Okay, we have the three up here, Judge Martin.
Who's ready?
We have all three, so whichever one you want to start with. We've got Hugler's, Mr. Knowles, and
Let's bring Mr. Ugler's time.
Hugler, okay. Jackson. Right here.
All right, this is, Mr. Ugler, you see and hear me okay? Okay, good. This is cause number CR 19-286, State versus Joni Denise Jenkins Jackson. I believe we're set for pretrial today. You have any contested pretrial motions, Mr. Ugler?
Not at this time, Your Honor. Is Miss Jackson, we just found out she was in custody. Is she in Van Zandt or in Athens?
Well, today she's in Van Zandt. I don't know if she was transferred back. I could ask jail staff on that. Ms. Abraham, will you check with jail staff to see if she's being housed primarily in Van Zandt or in Henderson, so Mr. Ugler will know? And Miss Jackson, can you tell us?
Yes, sir. I was transferred from Van Zandt today. They said I would be transferred back to Henderson County today.
So it seems like she's being held there, Mr. Ugler. So,
Yes, sir.
all right. If there's no contested pretrial motions, then Mr. Ugler, if there's no other issues, then I'll just set this for docket call. Are you available on May 11th, Mr. Ugler?
Yes, sir.
Okay, we'll go ahead and set Ms. Jackson then for docket call on May 11th. And do you have all, I guess, I'm assuming you have all your discovery and you've been given access to online portal? Okay.
We do now, yes.
Okay, good. All right. Well, if there's any issues that come up on pretrial, just let me know and we'll get those sorted out. So Ms. Jackson, court has set you for docket call on May 11th. So this will be the time that Mr. Ugler and the state are discussing your case. And if the state's going to make an offer, then they'll make it during this time. And hopefully we'll come back on May 11th and y'all will have talked and decided if you're going to enter into a plea agreement or request a jury trial. Okay.
Yes, sir. Well, I'll be speaking to my attorney, Mr. Hugler, between now and then. He'll come see me.
Yeah.
Okay. Thank you so much. Thank you, Judge.
All right. You're welcome. All right. Thank you, Mr. Ugler. Appreciate your patience.
Have a good day, sir.
You too.
Okay, Ms. Thompson's ready also again. Please call me.
Okay. Afternoon, folks.
All right. Who do we have available? Mr. Knoll.
Mr. Gomez.
All right. Mr. Knoll, you see and hear me okay?
I do, Your Honor.
All right. Mr. Gomez, can you see and hear Mr. Knoll? Okay.
Yes, sir.
Okay, good. All right. This is CR 15-456, State versus Stephen Ray Gomez. I show that we are set for a plea today on the motion to adjudicate. Is that correct?
Judge, that is what was said. I've been in contact with, I believe, his employer when he's not in Van Zandt County Jail in an attempt to try to alleviate some of the several $1,000s behind in costs. I got an photograph yesterday of a cashier's check that is supposed to be on its way that would actually clear all of the back fees but $20. So I think the total back fees are $3,020 as of what is filed. So I would like to be able to put this off until I don't like to say I will be getting, I would rather say I have in hand. So if we could put this off, the two of the paragraphs, the last two paragraphs appear to be the same allegations. Then there are a couple of other paragraphs actually, which are a couple of years old at this time. So I'd just like a little more time to see if we're actually going to have in hand funds to try to help in this case to catch up on fees that are, I think the total is $3,020 behind.
What was going to be the plea today?
Judge, we hadn't resolved the plea. There was a couple of offers out, but I couldn't respond one way or another and didn't get the information until late yesterday that something was supposed to be on its way. Apparently sometime yesterday, the 24th, it was placed in the mail.
State, do you have a position?
Judge, we've made two offers to Mr. Knoll. One, if he could prepay all of his back financial obligations, and one if he did not. If Mr. Knoll has information that he will be able to make up his financial obligations prepaid to this, we would be interested in giving him some time to do that. Not an extensive period of time, but if we could have a couple of weeks to see if we can come up with the financial obligations, we would then be willing to offer Mr. Gomez the lesser of those two offers and proceed in that manner. State would agree that to give Mr. Knoll a few weeks at the court's discretion.
Do both
Judge,
do both of the offers mean he's going to do time or what?
Yes, Judge. One was a lesser time offer if he prepaid all of his financial obligations. The other was a little longer, and then he would still obviously owe the financial obligations.
All right, let's do this. This is what I think, Mr. Knoll. Let's just set it for a contested hearing on April 29th. That's going to give you 30 days between now and then for you to determine if the money's going to come in and whether or not, he hasn't even accepted a plea agreement yet. So let's set it for 29th so we have a resolution deadline at least. And then between now and then, if the money comes in and y'all finalize a plea agreement, then you can contact the court, and we can get you set, in a week or so or 2 weeks.
okay, yeah, that'd be fine, Judge. I think we can hopefully have it worked out, certainly within 2 weeks anyway.
Okay, so court's going to set this for a contested hearing on April 29th. If the case gets resolved before then, I have settings available beginning April 1st, 13th, 15th. So we can always get him pled out sooner if we needed.
Okay, thank you, Judge.
All right.
And I'll meet obviously with Mr. Gomez and get with Mr. Woodwick before then.
Okay. All right. So we'll see you back on the 29th, Mr. Gomez, if not earlier.
Thank you, Judge.
You're welcome, sir. Thank you.
I'll be zooming elsewhere here shortly.
Zoom out of here already.
Thanks, Judge.
Judge, we have Mr. Fitzgerald, and then Miss Thompson is ready on Miss Dane again.
All right, let's go ahead and bring Ms. Thompson up. All right, we're back on the record in CR 2288, State versus Mary Louise Dean. And Ms. Dean, have you had more time to talk with Ms. Thompson about what we discussed before on your case?
Yes, sir.
All right, and Ms. Thompson, is the announcement still a request for a jury trial?
No, Your Honor, she does want to go ahead and accept her plea, but we don't have any paperwork ready, so I guess we need a plea date.
Okay, would you be available next Thursday on the 1st?
On the 1st, yes, sir, I would be, but whether or not she gets quarantined when she gets picked to Athens remains to be seen. She's been trying to see medical all day with apparent symptoms of COVID. So she may get over there and get quarantined, is all I'm saying.
Okay, well, let's set her for next Thursday and we'll see if that happens. Then perhaps we can still get her pled out via Zoom from Henderson County.
Yes, sir.
All right, Ms. Dean, we'll see you back on the 1st. And then If you get quarantined, then we may just have to reset your case. Otherwise, we'll try to Zoom you from Henderson County. All right, thank you, ma'am.
Want me to remain, Your Honor, until we find out something about Ms. Carter?
We'll just ask Ms. Abraham there. If she's not heard back from Ms. Carter, then we'll just reset her for April 1st as well.
Yes.
No, sir, I have not.
Okay, all right, let's just reset her arraignment until April 1st, next Thursday, and they both may be in Henderson County together.
Your Honor, thank you, Madam. You serious?
Yes, ma'am, thank you.
Okay, now we have Mr. Fitzgerald.
All right, State versus Laquaylen, Fitzgerald, CR 2119. Mr. Fitzgerald, is my understanding that you're hiring an attorney to represent you?
Yes, sir.
Who are you hiring?
I haven't figured it out yet, sir. Didn't know I was going to come to jail and all this.
How long have you been in jail?
A few days now.
Few days. I think it's important for you to know that you're charged with a first-degree felony offense of manufacture or delivery of a controlled substance in penalty group 1, 4 grams to 200 grams. That carries a very high range of punishment, Mr. Fitzgerald. It's 5 years to 99 years or life. All right. So how long do you think it would take you to hire an attorney? Do you have family members that are going to be helping you?
Yes, sir.
Okay. So if I reset you for a week and checked with you next Thursday, do you believe that your family may have been able to hire someone by that time?
Right. Yes, sir.
Okay. Well, tell me though, is your family members working for you now? Are they trying to assist you, or what's your situation?
Yes. I mean, right now, all I got is my mom, and right now I can barely contact with her because she works here.
She works where?
She works for the county, sir.
She works for the county. Okay. Well, let's.
They gave me a bond, but my bond is too high for me to get out.
I understand. Well, right now I'm not as worried about your bond as I am about your attorney. Okay.
Yes, sir.
Oftentimes, money is better spent on an attorney who then work on getting your bond lowered.
Yes, sir.
Okay. So I'm going to reset you to next Thursday, and we'll revisit at that time. Between now and then, I want you to work hard at getting in contact with your mom or another family member and see if they can assist you in getting an attorney hired so we can get your case moving. Okay.
Yes, sir.
All right. So we'll see you back on April 1st, next Thursday. Hopefully we'll have an attorney by then.
Yes, sir.
Mr. Fitzgerald, let me ask you another question. Were you employed before you went to jail? No? So how did you support yourself?
I was getting unemployment.
Unemployment? How long have you been on unemployment?
I've been on unemployment since the virus started. I was living in West Texas and I was employed there.
And you became unemployed once the virus started?
Yes, sir.
Do you think you have enough money to hire an attorney? Do you own any property, home, car, assets?
I mean, as of right now, and my taxes, I think I do have enough to hire an attorney.
You think you do?
I think.
Okay. All right. Well, let's try to get that figured out before next week.
Yes, sir.
Otherwise, you're just going to be sitting there and nothing's going to be happening on your case, and you don't want that. Okay. All right. The bailiff's going to give you a notice of setting here. You'll sign that. You have your next court date on it. Who's next, Mr. Abraham?
Mr. Sanders is speaking to his two gentlemen that are talking about pleas today. So we're down to those two.
Okay. All right. I'll just stand by whenever they're ready.
Thank you. Okay, we have Mr. Carter. And
All right.
Mr.
CR 17278, State versus James Larry Carter. I show we're set for a plea today. Is that right, Mr. Sanders?
Yes, sir, that's correct.
All right, and this is a motion to revoke or adjudicate.
Yes, that's correct.
Which one is it? Revoke or adjudicate?
Should be adjudicate. Let me make sure we got it. Yeah. Yeah, so to adjudicate.
All right, Mr. Sanders, what's the plea agreement today?
Judge, the agreement's for 5 years TDC and then the balance of the financial obligations. And he'd be pleading true to paragraphs 2, 3, and 4 in the motion to adjudicate. And I think the state was going to abandon the paragraph 1 or count 1.
That's correct, Your Honor.
And what kind of credit time does Mr. Carter have?
59 days.
59, 59?
59, yes.
All right, Mr. Carter, if you will, please, sir, raise your right hand so I can place you under oath. Mr. Carter, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can put your hand down. All right, Mr. Carter, are you a United States citizen?
Correct, I am, sir.
Do you read, write, and speak English?
I do, sir.
And have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jeff Sanders. Are you pleased with his representation of you?
Yes, sir. Yes, sir.
Do you feel like you've had enough time to discuss the state's motion with him and have all of your legal questions answered?
I do, sir.
And is there anything about the plea agreement today that you have read and signed that you do not understand?
No, sir. I've got everything. I understand everything correctly, sir.
Okay, thank you. All right, it appears to me that you were before the court on December 7th of 2017, and you pled guilty to the offense of aggravated assault with a deadly weapon. The court reviewed the evidence, found that there was enough evidence to convict you. However, the court did not and followed the plea agreement in your case, and the court deferred a finding of guilt and placed you on community supervision for 6 years. The court also assessed a $2,500 fine. It was during that period of your community supervision that the state filed a motion to adjudicate and revoke. Mr. Sanders, did your client waive the formal reading of the state's motion today?
Yes, Your Honor, we would waive the reading of the motion.
All right. So, do you have that motion there with you, Mr. Sanders?
Yes.
I can have it displayed, but it may be easier for him to look at it if you have it. So, Mr. Carter, what I'm going to ask you to do is to look at the state's motion to adjudicate, and I'm going to ask you to review counts 2, 3, and 4. And I'm going to ask you, how do you plead to those counts? Are those counts true or not true?
Those are true, sir.
And Mr. Carter, are you pleading true to those because those things are true and for no other reason?
They are true, sir.
All right. And has anyone threatened you, forced you, or pressured you to make you feel like you had to plead true to those counts?
No, sir.
All right. I'm going to accept Mr. Carter's plea of true at this time. Mr. Sanders, is there any objection to the offer and admittance of State's Exhibit A?
No objection.
All right, State's Exhibit A is admitted into evidence, and the court takes judicial notice of Mr. Carter's pleas true in his judicial confession. Is there anything further from the state?
No, Your Honor.
From the defense?
No, Your Honor.
All right, Mr. Carter, based on the evidence before the court will find that counts that you have violated the terms and conditions of your community supervision. Court finds counts 2, 3, and 4 in the state's motion to be true. Court hereby revokes your community supervision pursuant to the plea agreement, adjudicates your guilt, convicts you of the second-degree felony offense of aggravated assault with a deadly weapon. The court assesses your punishment at 5 years confinement in the Texas Department of Criminal Justice. The court orders you to pay the balance of your financial obligation and also awards you 59 days credit towards your sentence for the time served in this cause. Mr. Carter, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of your sentence. I'm going to have you go with the bailiff to be fingerprinted. Good luck to you, sir. I'm sorry, Mr. Sanders, while you're waiting, this morning, while you were in Gregg County, we had Terry Glenn Vance on this morning's docket, and he was set for arraignment. I think you were not appointed until March 16th. Miss Debbie Beasley stood in at the court's request, and we arraigned Mr. Vance. He's charged with a state jail felony, possession of controlled substance, and penalty group 1. I debated on which day was better for you, and I thought Thursdays were your tough day. So I set that on Tuesday, April 27th. So if that's going to be a problem, you'll just file that motion for continuance and let me know, and we can try to get a reset. Otherwise, that's the notice of setting that he received.
Okay, yeah, I think that should be fine.
Okay. All right, so Mr. Herron, is he the last one we have?
Yes, right, he is.
Is he ready, or are we still working on paperwork?
Judge, I think we're ready. We're not quite ready to do the pleas yet. Judge, we have an agreement. Ms. Curry and I have been talking. She had given us 2 different options, and I talked with Charlie about those, and then I went and talked with Ms. Curry a little bit more about them. But then I had to talk with Charlie again after I talked to Ms. Curry. But I think the paperwork we got ready is for one option, but I think he decided he wanted to do the other. Basically, the options were either a 15-year sentence on the arson case, and then also a 10-year sentence on the revocation, and then they would 1245 the failure to appear, or 10 years on the arson and the family violence revocation, and then 5 years on the failure to appear that would be stacked on the 10. And I think initially, basically, I just kind of, after we talked initially about it, and I talked to Ms. Curry, I just didn't get back over here and have a chance to talk with him yesterday to know for sure which one he wanted to do. So I told Ms. Curry in the DA's office the one option, and I think he's decided he would want to do the other option. So all that to say, I was going to ask if we could reset his pleas for next Thursday afternoon, if that would work. There's also an issue about back time. I think we may not have all the correct back time on the different cases. I need to get with the DA's office about that.
There's no way we could get that done in the next 2 hours?
I guess we might be able to.
Would Miss Abney be able to get paperwork done and we could email it out to the jail? And
I believe so, Judge. The only issue is if there's, if they have some kind of back time that we don't show credit for, they may have to provide us documentation of that. So I don't know if that could get done today. And like you said, this is Miss Curry's case. I don't believe she is present right now for us to ask her about it, but I believe we could probably get it done.
that makes me hesitant.
The state would personally prefer to do it next Thursday if it would please the court.
Okay. I'm just trying to get our inmates processed out and moved and get our cells cleared. All right, so court will reset Mr. Herron then for plea on April 1st. And that will be at 1:30. Do you have any conflicts that day, Mr. Sanders?
Not for the afternoon, that'll be fine.
All right, that'll give us a chance to get all the back time and all that done correct, so we do it once.
And that's what I told Charlie. We'll sit down after we get out of here and make sure I've got the right dates. Because I know he had a considerable amount of back time in Henderson County and just making sure we get it all correct.
Okay. All right, then we'll see you back on April 1st, Mr. Herron. And I think that completes our jail docket. Is that correct? Good joint was reset to April 1st. We reset that without bringing him up.
Did Mr. Harris reset, Judge?
Yes, Mr. Harris said that. Down. The Johnny Harris, is that the one you're asking about?
Yes, Your Honor.
How come I'm not seeing him. He was this morning though, wasn't he? Okay, yes, Johnny Harris this morning. He appeared, it was April 27th for MTA, MTR.
And Miss Curry has just walked in.
Okay, so hey, let me stop the recording here and stop our live stream.
And we still have two inmates in here. But
That we need to call?